All right. Hey, my name is Josh Hunking. I'm a lawyer in the Willamette Valley, also the author of How to Fix the World, which is coming out soon. Answering some questions. This particular one is, what are Miranda rights? What they're referring to, this is an American concept, and they're referring to the Miranda case from the Supreme Court of the United States. In essence, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney. If you cannot afford an attorney, one will be appointed for you. You have the right to have the attorney present before any questioning. Do you understand these rights? Is basically what it is, right? There's a couple of components, but what you're trying to do is provide prophylactically information to people who may not otherwise have that information, that these are the rights that you actually have under these circumstances, to try to combat the coercive environment of a police interrogation. So in the United States, it's under the Fifth Amendment. In Oregon, I think it's Article 1, Section 12. It might be Section 11. I would have to double check. That has your right against compelled incrimination. Now, the right against compelled incrimination is important for a couple of reasons. In Oregon, I think in the Fish case out of the 90s, and what John Henry Hinkson really espoused was that you're trying to avoid the trilemma. And the trilemma is, all right, we're going to put you under oath. This is if you allow your government to compel incrimination. We're just going to put you under oath. And now that you're under oath, we're going to ask you a question. Did you murder that guy? To which you really only have three options. You say, yes, I murdered the person, at which point we're going to kill you. Because, if you go back a couple hundred years, the punishment for murder would be death. And we're going to kill you if you say yes. Or you say no, in which case you've just committed perjury because you're lying under oath and you're a criminal and we know that you murdered that person, so we're going to kill you for perjury. So you're dead anyway. Or in the alternative, you refuse to answer, and if you refuse to answer, well, now you're in contempt of court, and we're going to either throw you in jail or punish you in some other way unless and until you decide you're going to answer the question. So from the moment that you're standing there and you're asked a question, hey, did you murder that guy? You're a dead man. And that's the problem, is that there's no way to get out of that, and that's what the trilemma is. My personal opinion is that there are also benefits. While it may not have been the purpose of the right against compelled incrimination, I think that compelled incrimination leads to bad information a lot of times. I mean, if your government is allowed to compel incrimination, they are allowed to torture you, is what it is. And there's several instances of that across Oregon and human history, and the ones that I think matter the most as sort of trigger points is if you go back as late as the 1930s, the police were using the third degree in order to be able to get information out of people, which means that they're punching you. The cops are going to come up and they're going to punch you until you tell them, yeah, I robbed that guy. There was a documentary on the original Night Stalker that I watched with my wife, where the cop was very, very proud of himself. I think it was the 70s. The way they were able to figure out who, I think it's Richard Ramirez is the guy's name. The way they were able to figure out who Richard Ramirez was is the cop got the witness in the back of the cop car and just punched him a few times. And, the person, okay, it's Richard Ramirez. And we were able to catch the Night Stalker. I mean, it was awesome that this cop was able to punch that information out of that guy. The cop was very proud of himself. And, I mean, if you prevented a future death, maybe it's good on the whole, but it's kind of unsavory, right? I mean, we seem to do the same thing again and again and again. I mean, we were waterboarding people like 20 years ago. It's not like it goes away. That incentive is there. But the problem with tortured information is that it's not necessarily reliable information. A person has reason to fabricate that information, and it's unsavory to get the information. There are better ways that we can... Janine tells me to sum it up. So in the end, Miranda rights are just a prophylactic. Here's the information that you get. You've got the right to remain silent. Anything you say can and will be used against you in a court of law. You get the right to have an attorney present before any questioning continues. If you can't afford an attorney, the government will pay for one for you. Do you understand these rights? That's to try to inform the person that your Miranda rights are, you can exercise these. You don't have to answer these questions as a prophylactic against the coercive environment of a police interrogation. Your response as a criminal defendant under almost all circumstances when somebody says, if you hear those words and you're being read Miranda, politely, I would like to have an attorney present before any questioning continues. And call me or call any other lawyer. You really should not provide any more information at that point. Nothing you say is going to help you after that point. So they've already determined that you're in trouble and you're guilty. And so stop talking, talk to an attorney, and get somebody who's on your side before you're just willy-nilly walking into a place where police may try to trick you. They may lie to you to try to get you to confess to something that you didn't even do. So until next time.